Welcome back. Today we are going to deal with legal research in particular. The meaning of the term legal research, why legal research is essential, and what are the classifications of legal research will be dealt in this particular section. So let us begin with the meaning of legal research. The term legal research takes into its ambit a systematic finding or ascertaining law on the identified topic on which the researcher wished to pursue his legal research. The area as well as an inquiry into law is essential and the purpose is to make advancement in the science of law. Thus, the legal research is the process of identifying and retrieving the information essential to support the legal decision making. It includes in each step of a course of action that begins with an analysis of facts of a given problem and concludes with the application and communication of the results of the investigation so that the researcher can finally give some concrete solutions to the problem on the basis of results of his investigation. Legal research is broadly classified into two different types, that is, doctrinal and non-doctrinal. If the legal research is doctrinal nature, then it is a research into the legal rules, principles, concepts, or doctrines. It involves a rigorous systematic exposition, analysis, and critical evaluation of the rules, principles, doctrines, and their interrelationships. It arranges the existing laws into a proper order and provides thematic parameters for such an order. It is concerned with critical review of legislations and decisional processes and their underlying policy. Involves an inquiry into the conceptual base of legal rules, principles, and doctrines, and provides stimulus and intellectual infrastructure for empirical research, as it is the base for empirical research as well as it is essential for advancement in law through legislative, judicial, and administrative process. Second classification of legal research is non-doctrinal, which is also called as empirical investigation. In this particular type of research, it assesses the impact of law and reveals the gap between the legal idealism and social reality. It helps to perceive the idea of law as a social phenomena, and here the researcher explores social, political, economical, as well as cultural dimensions or implications of the law. It is also called as reform-oriented research because it is based upon empirical study and critical examination of law and recommends changes in the law and legal institutions. Legal research is important, or what is the need of legal research? Legal research is essential for ascertainment of law on a given topic or subject. It is also essential to highlight the ambiguities and inbuilt weaknesses which are already present in law so that they can be done away with. It is also essential so that critical examination of legal provisions can take place. Principles or doctrines can be critically evaluated so that to view its consistency, coherence, and stability of law and its underlying policy. Apart from the above, it is also essential to undertake social audit of law with a view to highlight its pre-legislative forces and post-legislative impacts. And it is also essential to make suggestions for improvements and in the development of law. The research is important because it is a way of thinking and finding answers to the questions that come into your mind. The researcher wants to get answers for these questions, and the procedure which needs to be followed in finding answers to such questions should be empirical as well as subjective. The techniques and procedures that need to be used should also be valid and logical. Hence, the research process requires scientific scrutiny, and procedure involved in this scrutiny should be valid and reliable. Hence, legal research must be done by keeping all these aspects in mind, and that is why legal research is important. Thank you.